Hello friends, I welcome you all to this session of Indian Evidence Act. Today we are going to discuss from section 52 to section 55, which deals with character, or which says that when character is relevant. So as usual, let us have a brief overview as to what all we are going to study in this session. So first we will see the relevancy of character in civil cases, that is, in civil case whether character is relevant or not. If it is relevant, then when it is relevant. Then the relevancy of character in criminal cases, that in criminal cases whether character is relevant and or not, and if it is relevant, then whether good character is relevant or bad character is relevant. Then what is character? So the definition of term character has been provided under section 55, and what is it, that also we will see, whether it relates to general tendency or whether it relates to particular tendency. Then section 53A, which has been recently added, we will see that also. So let's begin. So here I would just like to say that when the character, as far as this relevancy of character is concerned, section 52 to 55 deals with relevancy of character. But in this, if we write here like this, 52, 53, 54, 55, then the first and the last section, that is section 52 and section 55, deals with character as far as civil cases are concerned, and the middle two, that is section 53 and section 54, these two deals with character as far as criminal cases are concerned, and in this 53A has been added. Now let's start and see how relevant a character is in civil cases. So section 52 reads, in civil cases, character to prove conduct imputed irrelevant. I lay down. Section 52 lays down the general rule that evidence of a party's character cannot be given for the purpose of showing that it renders the conduct imputed to him as probable or improbable. So what it says is that whether, suppose A is a person and there is a conduct C1 imputed to him, then, or a conduct say D1 imputed to him. Now in this case, his character, the character of A, cannot be proved, that as this is the character of A, therefore most probably A must have done this act of D1, or as A has a character of CA and the persons of this character generally do not do conduct of D1, and therefore it is impossible that A has committed the act D1. So this is not, or this is has been made irrelevant under section 52. So what has been made relevant, irrelevant under section 52? Character of a person from which conduct can be imputed or conduct can be contradicted. That is, we cannot prove the character of a person, and based on that character conduct can be imputed, then that character cannot be proved. So in Hollington versus Hawthorne, it was held that evidence cannot be given of previous conviction for careless driving arising out of same accident for which civil action is brought. So the general rule is laid down in section 52 that in civil cases, character which imputes a particular conduct is not relevant. However, there are exceptions to it. Now, two exception has been made within section 52 itself, and one exception has been made in section 55. Now, the first is that when character appears from other relevant evidence. Section 52 last line provides that except insofar as character appears from facts otherwise relevant, the court is free to form an opinion as to character of a person on the basis of the relevant facts proved in the case. So, if based on the other facts a character appears, then this becomes relevant. But if from the character a particular conduct is imputed, then that is irrelevant. Then another exception is that when character of a person is itself in issue. So when the character of a person is itself in issue, that whether he is of good character or she is of bad character, then in that case section 52 says that it becomes relevant. Now this flows from section 5, which states that evidence may be given of fact in issue or relevant fact. So when character itself is a fact in issue, then under section 5 it becomes relevant. So section 52 it says generally in civil cases character which imputes a particular conduct or character which makes a particular conduct improbable, that character evidence is irrelevant. But it makes two exceptions. One, that when character appears from other facts, or when the character of a person is itself a fact in issue, then it becomes relevant. Then in the section 55 it says that in civil case the fact that character of any person is such as to affect the amount of damage which he ought to receive is relevant. So when suppose there is a plaintiff and there is a defendant, and the amount of damage which plaintiff will receive depends upon his character, depends upon the character of P, then at that time character of P or character of plaintiff becomes relevant. So this good or bad character is that with regard to the plaintiff or the person who is going to receive the damage. Now, this is what is character in civil cases. So what is section 52? Character generally is not relevant, but there are certain exceptions. When character comes out from the other facts, it becomes relevant. When character itself is an issue, it becomes relevant. And in third exception is that when character determines the amount of damage which a person is going to receive, it becomes relevant. Now, third thing is which is given under section 55 is what is character. So it says character includes both reputation and disposition. Please mind you friends that there are two parts in this explanation. One, what character includes, and then what type of them. So first it says that character includes both reputation and disposition, but evidence may be given only of general reputation and general disposition and not of particular acts by which reputation or dispositions are shown. So explanation to section 55 says that character includes two things, reputation and disposition. And this reputation should be general reputation, this disposition should be general disposition. Now, it should not be particular act, particular reputation or particular disposition. Now generally we will see what is reputation and what is disposition. But before that, if we say in simple words what is character, then character is the habit of a person which he generally shows in a public place or in a society. Habit of a person which he generally shows in society. Now there are two things which consist of character as given under section 55. One is reputation. So what is reputation? Reputation is what is thought of a person by others, that and is constituted by public opinion. So if this is a person A and there is a certain opinion about him by B, certain opinion about him by C, certain opinion about him by D, then the general thing or the common thing between what D, B, C thinks about A is his general reputation. And what is disposition? Disposition is how a person acts in a particular circumstance. That within a given circumstances, how a particular person acts. That whether if there is a in that particular circumstances he becomes very angry or he becomes very violent, then that becomes his disposition. Mind you, friends, character as given under Indian Evidence Act is general and not particular. So, if at a particular time in that circumstances he became very angry, then that will not be taken as his character. But if generally in that particular circumstances he becomes very violent or very angry, then that will be his general disposition and it will be relevant under section 55. Now, relevancy of character in criminal case. Now in criminal case, as I told you, there is 53 and 54 section. Now 53 says that if the character is that of good character of accused, then it is relevant. And if that is, section 54 says, if it is the character is that of bad character of accused, then it is irrelevant. So accused good character is relevant, but accused bad character is not relevant. So section 53 provides that in criminal proceedings, the fact that person accused is of good character is relevant. So this is what is here. Section 54 provides that in criminal proceedings, the fact that accused has a bad character is irrelevant. So, accused has a bad character is irrelevant under section 54 in criminal proceedings. So, the general rule in criminal proceedings is that good character of accused is relevant, while bad character of accused is irrelevant. Now, but there are certain exceptions to this, that bad character of accused is not relevant. What are those exceptions? One exception is that when bad character of accused is relevant in criminal proceeding, one is that when when evidence of good character has been adduced by the accused, the evidence of bad character can be given by the prosecution. So when the accused shows that he has a good character, it becomes relevant under section 53. At that time, as per explanation 1 to section 54, as per section 54, the prosecution can give evidence to show that no, he is not of good character, rather he is a person of bad character. And second, when bad character of a person is itself a fact in issue, when the bad character of that person is itself a fact in issue, then as per explanation 1 of section 54, as well as per section 5 of Indian Evidence Act, it will become relevant. Then, how do we prove bad character? So, previous conviction is a evidence of bad character, that earlier also he has been convicted. That will be a proof, or that will be an evidence of his bad character. So bad character can be proved by previous conviction as per explanation 2 to section 54. So that is what is section 53 and 54. Now 53A has been added in 2013. This is very important and it has been asked in examination many a times. What it says is that when suppose there is a person A and B, now B has accused A of offenses under section 354, that is sexual harassment or molestation, or section 376, that is rape, various parts of it, A, B, C, D, E, or an attempt to commit it. Then now suppose A says that the question is whether it was with consent or whether the consent was not there. That is, if the sexual activity takes place between A and B accuses A of rape, and A takes the question is A says that she had given consent, and the question is that whether there was consent or not, B denies it. So the question is whether there was consent or not, and if there was consent, then what was the quality of that consent. Then evidence cannot be given that normally the B is of bad character. Then the character of B will not be relevant to show that as she is of bad character, so she may have given the consent. This is there. And second is that evidence also cannot be given that A and B were having regularly sex earlier also. That is, A and B were habitually in sex with each other. Each individual act of sex should be with the consent of both the parties. So when the question is, when a person has been prosecuted in the section or is charged with section 354, various parts of it, or 376 and various parts of it, or an attempt for it, that is rape or molestation or harassment, and the question is that of consent in issue, that whether there was consent, and if there was consent, then what was the quality of consent, then the evidence of character of the victim or previous sexual experience with any person, accused or any person, shall not be relevant on the issue of consent. So this is what which has been added in the section 53A. Now just we will have a quick review as to what all we studied. So we studied under section 52. It says that when there is conduct, and that conduct is when character is to be given, that whether this conduct is probable or improbable because of particular character of a person. In that case, in civil cases, character of a person is irrelevant. However, when the character appears from facts otherwise relevant, it becomes relevant, or when the character itself is irrelevant, it becomes relevant under section 5. Under section 55, character, if the character affects the amount of damage which a particular person is to receive, then in that case his character becomes relevant. Then as per section 55 explanation, character consists of reputation and disposition, and that too reputation and disposition should be general in nature and should not be particular. Then as per section 53, good character in criminal proceeding is relevant. As per section 54, bad character in criminal proceeding of the accused is irrelevant. However, there are certain exceptions to it. One is that when evidence of good character has been given by the accused, then character of bad evidence can be given by the prosecution. Another is that when bad character is itself in issue, then it becomes relevant. And third is how to prove bad character. One way is that previous conviction of the accused is an evidence of bad character of the accused. Then section 53A, that when a person has been prosecuted for offense under 354, 354A to D, 376, that is rape, 376A to E under Indian Penal Code, or an attempt for it, and where the question is that whether there was consent or not, and if there was consent, then what was the quality of consent, and two things have been made irrelevant, that is the character of the victim and previous sexual experience of such person with any person. And the word here is shall. So it's not discretion upon the court, rather it is mandatory on the court. So shall not be relevant. Thank you, friends.